Hi, my name is Anne and I work at the International Civil Liberties Monitoring Group. Today I want to talk to you about extradition in Canada. First, what is extradition? It's the legal process by which the Canadian government sends individuals, including Canadian citizens and permanent residents, to face criminal prosecution and incarceration in foreign countries. Why do I want to talk about it? Because the extradition process in Canada is broken. One of Canada's leading extradition experts calls it the least fair law in Canada. It is discretionary and political, lacks transparency, and is stacked against the person facing extradition. It has real devastating impacts. Take the case of Hassan Diab. In 2014, Hassan Diab, a Canadian citizen, was wrongfully extradited to France and held in solitary confinement in a maximum security prison for over 3 years. He was eventually released without ever being formally charged after a French judge found that the case against Dr. Diab was profoundly flawed and that evidence showed he was not even in France on the day the crime he was suspected of occurred. The judge overseeing the extradition hearings in Canada called the French case weak, very problematic, very confusing, with conclusions that are suspect, and stated that a conviction seems unlikely. Despite all this, Canadian officials aggressively pursued Dr. Diab's extradition. Media inquiries eventually produced evidence of concerted efforts by Canadian Justice Department lawyers to shore up the French case, including by withholding exculpatory evidence, which the Extradition Act currently allows. Hassan Diab's case is emblematic of a process that has been reduced to a rubber stamp. It needs to change. The problems with Canada's extradition system can be broken down into 4 parts. 1. The committal process, where courts decide if a person will be extradited to face trial or not, is unfairly biased in favor of the foreign state. It doesn't allow the person sought to introduce exculpatory evidence. It assumes evidence presented by the foreign state to be reliable, and it permits extradition and deprivation of liberty on the basis of unreliable material that would not be accepted in a Canadian criminal court. 2. The decision to surrender a person to extradition made by the Minister of Justice is the product of a discretionary and explicitly political process, which is also unfairly weighted toward extradition and against the rights of the person sought. 3. Justice Canada's International Assistance Group, or IAG, is excessively adversarial in the way it conducts extradition proceedings, focusing on winning cases when they are not actually meant to serve as prosecutors. Even more troubling, the IAG both assists the foreign state in making its case and advises the Minister of Justice on whether extradition should be granted, so it acts as both the prosecutor and the judge. And 4. Canada's international cooperation on criminal investigations is generally conducted under a veil of unnecessary secrecy, and lack of transparency is a serious problem. In 2018, a group of 7 legal and human rights experts gathered for the Halifax Colloquium and put together a set of 12 recommendations to reform Canada's broken extradition system. 1. The Extradition Act and related policies should be amended in accordance with 3 general principles: fundamental fairness, transparency, and a rebalancing of roles, both between the courts and the government, and between charter protection and administrative efficiency. 2. It should not be presumed that states with which Canada has extradition relations will act in good faith. Explicit safeguards against countries that issue extradition requests for political reasons should be put in place. 3. The committal process should incorporate the presumption of innocence. It should also allow the person sought to meaningfully challenge the reliability of the case against them. In particular, exculpatory evidence in the hands of either the requesting state or the Canadian government must be disclosed. 4. The minister's surrender decisions should be subject to a higher standard of review. Some of the questions in the surrender phase should be considered by the courts and not by the government. For example, whether the individual sought would face double jeopardy, prosecution for political crime such as treason, unfair trial, serious mistreatment including torture, or other unjust or oppressive treatment. 5. Surrender should only be permitted if the requesting state shows evidence it is ready to take the case to trial. 6. Canada's obligations under international human rights law should be taken explicitly into account throughout the process. 7. If there are concerns about the treatment of individuals in the requesting state and diplomatic assurances are used to facilitate surrender, they must be meaningful, transparent, monitored, and legally enforceable. 8. The role of the International Assistance Group should be reformulated so that its members work to obtain a fair and just result in each case rather than a win. 9. There should be oversight of the International Assistance Group and meaningful public scrutiny of its activities and of the extradition process generally. 10. In cases where Canada could prosecute, extradition should be barred in favor of Canadian prosecution unless the government can prove that it is actually in the interest of justice to extradite. This would give meaning to Section 6 of the Canadian Charter of Rights and Freedoms, which states that every Canadian citizen has a right to remain in Canada. 11. All of Canada's extradition arrangements with foreign countries should be reviewed and subjected to public scrutiny on an ongoing basis. As a starting point, Canada should not have extradition treaties with countries that have records of human rights abuse and have failed to ratify human rights treaties. And 12. The Government of Canada should heed the repeated calls to dedicate more resources to investigating and extraditing alleged perpetrators of international crimes such as genocide, crimes against humanity, war crimes, and torture who are present on Canadian territory. It is crucial that the government acts to fix Canada's flawed extradition system. You can take 2 actions today to change the system. 1. Share this video with friends and family. And 2. Send a letter to the Prime Minister, the Justice Minister, and your MP by visiting ICLMG.ca. If you'd like to read the full Halifax Colloquium report and learn more about Hassan Diab's case and his fight for justice, check out the links we've included in the video description. ICLMG is a Canadian coalition of 45 national civil society groups that came together after the adoption of the Anti-Terrorism Act of 2001 to protect civil liberties from the negative impact of the so-called War on Terror. To see more videos like this one and support our work of protecting civil liberties in general, please visit iclmg.ca/donate or patreon.com/iclmg and get rewards. Thank you.